you for joining. So today we are talking about different legal principles that apply to business organizations. So if you're here, chances are you have a business idea and you're looking to execute it, okay? So can we do a quick roll call? And can you all just tell me from where in the country you're tuning in? I'm in Monterey County, California.
Monterey County, California as well.
Can I ask that you all tell us in the chat function? So thank you, Ms. Glover. Okay, we see Fresno, New York, Paso Robles, Monterey County, Philadelphia, Oakland. Okay, all over, nationwide. So again, if you're here, you probably have a business idea. So if you're comfortable telling us, please let us know what your business is in the chat. Education and health, hair, holistic and spiritual wellness business, medical transport, assisted living, HR services. Okay, excellent, excellent. Coffee bar, okay, phenomenal. All right, last question for now. Can you please tell me something you're hoping to learn today? What can we talk about today that's going to help you and your business or help you start your business? Okay, how to fund your business, absolutely. How to maintain your business, okay. Okay, commercial insurance, risk management options. Okay, so today, I'm sure there's going to be something that everyone on the line can take away. So as Ms. Saunders said, my name is Brianni Lyons. What can I say that she hasn't already said? Like many other military families, my family arrived at Fort Ord in Monterey County in the 70s. And since then, my family has contributed to Monterey County's economy with commercial and residential real estate development. Entrepreneurship is what has supported the educational pursuits of many members of my family. Just last year, my brother graduated with a Bachelor of Science in Economics. We're very proud of him. So now, as a lawyer licensed in California and New York, it is my absolute privilege to be able to help entrepreneurs like you achieve your business goals, okay? As a lawyer, it's important for me to give extremely thoughtful advice to my clients, and I have 3 primary practice areas: compliance law, corporate governance, and contracts. What we're talking about today, business organizations, that is within the realm of corporate governance law, okay? So someone in the chat said that one of their goals or what they want to know today is how to maintain a business. And that's exactly what I help entrepreneurs do. I help you start your business and I help you keep your business, okay? I help you maintain compliance while maintaining competitiveness, okay? And a big part of what lawyers do is teaching, in my opinion, right? By helping you understand what's going on, I can empower you to make confident decisions. Typically, people don't trust what they don't understand. So if I can get you to understand something, hopefully I can get you to trust in the process. All right, before we begin, I have to say it, this is not legal advice. Please do not construe it to be so. If you want legal advice, we can talk about it, but this presentation, this is not legal advice. There are 3 main topics for today. We're going to talk about the California Business and Professions Code. You'll hear me abbreviate it as BPC. Within that, we'll talk about the different business activities and the different professionals that are regulated by the BPC. We will distinguish legal names from fictitious names, from trade names. We'll also talk about the purpose of state trademarks and how a state trademark differs from a federal trademark. And we'll also talk about non-compete agreements. When we get to business organizations, we will identify the different types of biz orgs that exist. I'm sure you all have heard of the sole proprietor, the corporation, the LLC. There are other business organizations that exist, like the general partnership, the limited partnership, the limited liability partnership, and the limited liability company. We'll identify them, we'll discuss the key similarities and differences. And then finally, we will identify two common fiduciary duties. So as entrepreneurs looking to start a business or to grow your business, it's important that you are aware of who the fiduciaries are in your company or in your business. All right, so let's get started. So I'm a lawyer. This is a presentation about the law, so that's where we have to start, okay? So which laws apply to business organizations? And let's start here with federalism, okay? In a federalist nation, power is divided between the nation's government and other governmental units. So in the United States, we have the federal government, and then we have state and local government. Why does that matter to your business? Because your business is subject to federal law and local law. Local law can include state law, city ordinances, and county rules. So as your business is subject to federal law and local law, that means your business is subject to federal regulators and local regulators. MCSC is located in the Central Coast of California. So a lot of the presentation today is going to be focused on California laws. But when we talk about business organizations, those concepts are in general and they apply typically throughout the country. So what we're talking about still applies to you no matter where you're located. All right, so first with the California Business and Professions Code, BPC. If you would like, I'll give you a second now to navigate to where you can find this law on the internet. Finding the law that applies to you is not as impossible as it may seem. So if you Google right now, California Business and Professions Code, you should see a hyperlink come up or a website link come up for leginfo.legislator.ca.gov. And if your screen is similar to what you see on my screen, then you're in the right place. So this is a state law, a California state law, and it regulates general business activity within California, as well as certain professionals within California. It's comprised of 10 divisions, okay? And I'm going to highlight 4 of those divisions for you. You see them with the arrows here. Division 3, professions and vacations generally. Division 6, business rights. Division 7, general business regulations. And Division 8, special business regulations. So BPC Division 3, this division contains special rules for certain professionals. Now, what you see on your screen is not an exhaustive list, but it's a lot of them, right? So if you are if you say you train guide dogs for people with visual impairments, there's a special rule in the BPC for you. I saw someone in the chat, their business is a hair salon. In California, there's a special rule for barbering and cosmetology, so there might be a special rule in Illinois for you. App-based drivers, there are rules for app-based drivers. If you're a mechanic for aircraft or cars, there are special rules for you as well. Now, Division 3 is for the certain professions. Division 8 is for certain businesses, okay? So again, there's a special rule in Division 8 if you are engaged in any of these business activities you see on my screen. Again, it's not an exhaustive list. So if you are in the business of community youth athletic programs, there's a special rule for you. Tanning facilities, gambling, if you're a certain kind of athlete, a boxer, a wrestler, martial artist, an equestrian, there are rules for you. All right, Division 6, business rights. So you all might have a name for your business. Some of you said that you already have businesses. Others of you said that you were looking to start a business. So you either have a name already or have a name in mind. So let's talk about, let's identify the different variations of names that you hear, okay? Your business's legal name is important because that is its legally recognized name. When the government contacts your business, this is the name that your government calls your business. A fictitious name is a legally recognized alias of your business, okay? And a trade name is the name that you use in marketing and advertising. So for example, say your name is James Smith and you are a resident of San Luis Obispo County, okay? Say you incorporate your business in California, you have a corporation, and the legal name of your business is James Smith Cleaners and Alterations, Inc. Maybe you don't want everyone knowing that you're the owner of this establishment, right? Maybe you want to maintain some privacy. So perhaps you file a fictitious name permit so that instead you can be called 5-Star Cleaners. But say you want to put a sign out, right, on your brick and mortar. Maybe you want to go by Slow Cleaners, right? Something short, something you feel will attract people to you. Slow Cleaners would be your trade name. Now, your business name is important, okay? And if you're looking to start a business and you have a name in mind, you want to make sure that that business name is available before you get to attach to it, okay? Every state agency that regulates businesses, typically it's the state's Secretary of State, they all have a website where you can, or a database where you can search the name of businesses that are formed in that state. So if you would like to follow along on your own, you can go to businesssearch.cos.ca.gov, and it'll take you to this business search database where you can search the name of different businesses. If you have a name in mind and it's available, you can reserve your name with the Secretary of State for up to 60 days. And what that means is that for a period of 60 days, no other business can form a business with your business's name. Now, there are some rules in California and other jurisdictions of what you can name your business, okay? And generally speaking, your business, you can't name your business a name that already exists, right? You can't, two businesses can't go by the same name in certain circumstances, right? Also, there are certain words that are forbidden from being in the name of your business. So if you are in a limited partnership or an LLC, you can't have the words bank, insurance, trust, trustee, incorporated in the name of your business. In addition to there being words that you cannot include in your business's name, there are words that you must include in your business's name. For a limited partnership, your business name has to have limited partnership or the LP abbreviation in the name. Same thing with the limited liability company in California. It either has to have limited liability company in the name or the LLC abbreviation. So your business's name is but one of the ways that consumers identify your business. The other way that a consumer can identify your business is through your trade name or your logo or your catchphrase. And that's where we'll get into trademarks. So what is a trademark? A trademark is any word, phrase, symbol, design, or combination that helps consumers identify your goods or services, okay? When we see the Nike check, when we see Just Do It, we immediately know who that belongs to. So a trademark can have commercial value for a company, right? And so companies want to protect that commercial value. And you do that by getting your mark registered as a trademark. Now, we talked earlier about federalism, and let's bring that back. There's a federal government, state government. When it comes to trademarks, you can have a trademark that is registered with the federal government and enjoys federal, right, national protection. And simultaneously, or you can have a trademark registered with your state and you can enjoy your state's protection. Now, if a federal trademark has a larger scope than a state trademark, why would you even bother getting a state trademark? In California, it's extremely relevant for cannabis brands. On a federal level, cannabis is illegal. So the United States Patent and Trademark Office is not going to give your trademark federal protection if it's associated with a federally illegal product, right? But in California, where cannabis use is permitted, the California Secretary of State will give your cannabis brand's logo trademark protection. The next division is Division 7, General Business Regulations, and Part 2 of Division 7 is entitled Preservation and Regulation of Competition. Okay, regulation of competition. There's an entire area of law dedicated to antitrust, right? Antitrust law, in other words, anti-competitive behavior. There are federal and state rules that prohibit businesses from participating in anti-competitive behavior. Well, why? Well, competition in the marketplace results in a better experience for consumers, right? If businesses have to compete with each other, they have to provide consumers with some type of competitive benefit, right? Maybe it's lower prices, maybe it's better customer service, okay? But consumers benefit from fair competition in the marketplace. The most common, or I think one example of government enforcement of anti-competitive behavior that we're all can be aware of is from the Federal Trade Commission. So if you're on Instagram, right, if you're on social media, you've noticed in the last couple of years that social media influencers are using hashtag ad or hashtag sponsored, right? The FTC is the same government organization that made Kim Kardashian put hashtag ad on her posts. They started this off, right? And the idea is that consumers need to know if a celebrity is being paid to promote a product, right? So in California, Part 2 talks about the regulation of competition in California. One of the provisions that I want to highlight for you today is the enforcement of non-compete agreements in California. And as you see here with this big red arrow, the statute says, every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is void, okay? What is a non-compete agreement? A non-compete agreement is an agreement typically between an employee and an employer. The agreement can be made at the beginning of employment, or it can be made at the end of employment. But typically, the agreement says that the employee will not compete with the employer's business for some period of time in some geographic scope. Now, in other jurisdictions, courts will enforce a non-compete as long as it's reasonable in its subject matter, its scope, its duration, and it serves a legitimate business purpose. In California, generally speaking, those non-compete agreements will not be enforced because it's considered an unreasonable restraint on trade. There are 3 exceptions here, okay? So in California, although a non-compete may not be enforceable against an employee, a non-compete agreement can be enforceable against an owner, right? So if you get a business partner, you all decide you want to go into business, it is unfair for you to then quit that business, right? And go start your own business that directly competes with the business you started with your business partner. So in circumstances like that, where a non-compete agreement has been executed, California courts may uphold those agreements. And that brings us to the end of our first topic, BPC. If anyone has a question about what we just went over, please drop your question in the chat. All right, we're going to get into business organizations now. So what is a business organization? Okay, A business organization is a legally recognized person, the same way that the law recognizes me as a person and you as a person. A business organization is also recognized by the law as a person. Now, this is different than being recognized as a human. We're not saying that business organizations are recognized as a human, they're recognized as a person. And as a person under the eyes of the law, your business can be able to hold assets in its name, to facilitate transactions in its name, to sue people and be sued in its name, right? So for many reasons, which we'll get into later, it's important for your business organization to have a separate legal identity from you, if possible. In California, and again, in most states, when you're ready to form your business, you're going to submit paperwork with that state's Secretary of State. I want to highlight for you California Corporations Code. So earlier we talked about the BPC. The BPC it regulates certain type of business activity. Right? The California Corporations Code regulates all activity, right? Regardless of what your business is engaged in. This code regulates the rules for certain business organization types. So if you're a corporation, no matter what industry you're in, if you're a corporation, there's a rule in the California Corporations Code for you. So you see here that the code is separated into different titles. So you have an entire section dedicated to corporations, one for partnerships, one for LLCs and unincorporated associations. So what are the different types of business organizations? We have the sole proprietorship, we have the general partnership, the limited partnership, the limited liability partnership, the limited liability company, and the corporation. If you all, for those of you that have already started your business, if you wouldn't mind telling us what type of business you have, and if you are looking to start your business, tell me which type of business organization you are most interested in knowing more about. And while you all type that into the chat, I'll tell you that the key similarities and differences between the different types of business organizations, it's the terminology, the legal identity, the management structure, the way assets are held, liability, taxation, filing requirements, and the fiduciary duties. Okay, so a lot of LLCs. LLCs are probably the most popular business organization type amongst entrepreneurs. You all know them. I wouldn't be surprised if today was the first time that some of you heard of the limited liability partnership. I'm going to tell you what the difference between an LLP and an LLC is. All right, so first let's get the jargon down, okay? There's different terminology associated with each business organization type. Sole proprietor, in a sole proprietorship, the sole proprietor and the business are the same. So there's only one person, and that person is called the proprietor. The proprietor makes all of the decisions, they have all of the liability, they hold all of the assets. It's unitary. With the general partnership, there are at least 2 general partners, and each of the general partners is entitled to participate in the day-to-day management. So understand that the person who owns the business is not by default the person who makes the decisions in the business. So in a general partnership, there are at least 2 general partners, and each of the general partners make the decisions. In a limited partnership, you have at least 1 general partner and at least 1 limited partner. Only the general partners make decisions in the limited partnership. In a limited liability partnership, you have at least 2 general partners, okay? And all of the partners make decisions. In a limited liability company, your owners are called the members, okay? And depending upon the type of LLC, either the members make the decisions or they hire a manager to make the decisions. And in a corporation, your owners are called shareholders, but the decision makers are your board of directors and your executive management team. So not only is there a difference in the terminology when we talk about the owners and the decision makers, but also the governing agreement. And the governing agreement is the document that explains how the business will be governed. It lists who the owners are, what their ownership is, what their rights are as owners. It lists who the decision makers are, what their the scope of their authority, what that is. It might also talk about what happens should they decide to close the business, okay? So the governing agreement is really important. In some states, in order to form your business, you are required to have an agreement in place. So a lot of LLCs, you all should have operating agreements in place. So why is it important for your business organization to have its own legal identity? It's for continuity. These concepts of entity versus aggregate, right? As an entity, the business organization exists separate from its owners, but in an aggregate, there's just a sum, okay? So for sole proprietors in this unitary model, your identity is the same as the business's identity. So when you pass your business, it ceases to exist. But when your business organization has separate legal identity from you, the business continues regardless of who the owners are. Separate legal identity is also important for how assets are held. Okay, as a sole proprietor, your assets are the business's assets. The business's assets are your assets. In the other types of business organizations, in the partnerships, the LLC, the corporation, the assets of the business is separate from the assets of the owners. And why does that matter? Liability. As a sole proprietor, you have full liability for the debts of the business. So hypothetical here, okay? Say you operate a bake shop, okay? Jane Smith, we'll bring her back. Your name is Jane Smith. You operate a bakery called Smith Bakery, okay? You have a house in your name as Jane Smith, and say you have a vehicle in Smith Bakery's name, okay? Say one day you sell a bad batch of cookies and someone gets ill and they have hospital bills. When that sick patron sues you, they are suing both Jane Smith as well as Smith Bakery. And if the court decides that that customer, that ill customer, deserves their medical bills paid for, the customer can come after the Smith Bakery car, and they can come after the Jane Smith house, because Jane Smith and Smith Bakery are the same person underneath the law, okay? So there's no separation of liability there, okay? Now, being a sole proprietor, it's from a paperwork standpoint, you know, it's the easiest and most convenient way to operate a business, but you have to understand that you have full liability for the debts of the business. But maybe being a sole proprietor is the best option for you right now. There are other ways to manage risk, like insurance policies, right? Professional liability insurance, umbrella insurance, business owners policy insurance, having automobile insurance. Someone on here said that, I think I saw an EMT business or service. So there are many different insurance policies that you can get, and there are insurance experts that can work with you to find the right amount of coverage for you. All right, so full liability for sole proprietors. Moving on to the GP, the general partnership. In a general partnership, each of the general partners have full personal liability for the debts of the business. However, that's only if the business is insolvent. So in the case of a general partnership, a creditor of the business must first go after the business And if there's any money that's still due to the creditor, they can then go after the owners. Conversely, the creditors of the individual owners cannot go after the assets of the business. Creditors of the individual owners must go after the owners. Okay. In a limited partnership, there are general partners and limited partners. The general partners have full liability. The limited partners have limited liability. Why? Why do the limited partners get limited liability? Because limited partners do not participate in the day-to-day management of the business when it comes to a limited partnership. They're kind of like passive investors. So because they don't have a hands-on role, they're not active, they're not controlling the decisions of the business, they are not held fully liable for the debts of the business. Now understand that if you somehow fail to file the proper paperwork to become a limited partnership, you might be recognized instead as a general partnership and have full liability, okay? How do you file the wrong paperwork? It happens, okay? Maybe you file, you thought you were filing the paperwork for a limited partnership, but you were filing the paperwork for something else, right? Okay. In a limited liability partnership, all of the general partners have limited liability. In the limited liability company, the members have limited liability. And in a corporation, the shareholders have limited liability for the debts of the corporation. There is an exception where shareholders can be held liable for the debts of the corporation. Now, don't get nervous, right? If you have stock in some corporation, don't be afraid that now you're liable for what they're doing. This concept is called piercing the corporate veil, right? As a shareholder, there's this veil in front of you and the liability of the shareholder, or excuse me, and the liability of the corporation. There's a veil between you, the shareholder, and the corporation. If you are a controlling shareholder, or somehow you are controlling the decisions of the company, right? You're forcing the company to make certain decisions, then a court might pierce the corporate veil and hold you accountable for your actions. Okay. Another main difference between the business organizations. Oh, I'm glad you asked about S Corp, right on time. So another difference between the business organizations is taxation. So there are two different concepts: pass-through taxation and double taxation. And again, disclaimer, this is not tax advice. You have to get a tax professional to advise you. But pass-through taxation is when the entity itself isn't taxed for its profits, but instead the owners are, okay? So the different types of business organizations that enjoy pass-through taxation are partnerships, LLCs, and S Corps. Double taxation is where the entity is taxed for its profits and the owners are also taxed for the dividends they receive. A dividend is a shareholder's piece of the pie. So if the business has profits, the business can decide to issue dividends to its shareholders. Okay, so Lisa, S Corp, I'll tell you that the S Corp can enjoy pass-through taxation. Sole proprietor. So let's just go through the different business organization types, kind of summarize them, any outstanding key points. So with the sole proprietor, the legal identity of the business and the owner are the same. So the organization's actions are imputed onto the proprietor. So the business, it can sue and be sued in the proprietor's name. It holds property and it contracts in the proprietor's name. They file their taxes, have the same names on there, okay? And the big issue with the sole proprietorship is the lack of continuity. The business ceases to exist when the proprietor passes. The general partnership. The general partnership is when two people come together to be co-owners of a business for profit. In a general partnership, you have at least two general members, or excuse me, general partners. and the general partners have full liability for the debts of the partnership. There can be two different types of general partnerships. That's the GP at will and the GP for a term or undertaking. A general partnership at will, it just exists, right? Until TBD, ... okay? But a GP for a term or specific undertaking is when the partnership only exists for a specified amount of time or for some specific purpose. For example, some type of joint venture, or maybe you want to get together with people in your community and put on a fundraiser, some type of annual fundraising event. Maybe you want to form a general partnership, right? When you form the general partnership and you get a partnership agreement in place, it then outlines what the roles and the responsibilities of everyone involved is. So why would you form a partnership instead of a corporation? Liquidity, right? There's greater liquidity in a partnership than it is in a corporation. In a corporation, you have all of these various levels of approvals and red tape, if you will, before certain types of decisions can get made. In a partnership, the ability to liquidate assets is more simple, or it can be at least. In a limited partnership, the main difference between a general partnership and a limited partnership is the degree of liability. A general partnership has two general partners that have full liability. In a limited partnership, you have at least one general partner and one limited partner. The general partner makes the management decisions and therefore they have full liability. The limited partner does not make management decisions and therefore they have a limited liability. So why would you form a limited partnership instead of a general partnership? Well, an example is for the family business, right? Say you have a family business and you want to bring in your kids, right? But maybe you're not convinced yet, right, that they are experienced enough or ready or whatever to participate in the day-to-day management of the business. So as the patriarch or the matriarch of your family business, you might make your children limited partners. That way, they are entitled to receive the profits from the business, but they are not entitled to make management decisions, okay? So it's like, yes, children, I'll bring you in the business, but no, I won't let you run my business. Okay. Moving on to the limited liability partnership. The main difference between the limited partnership and the limited liability partnership is the management structure. So in the LP, you have one general member, one limited member, or excuse me, one general partner and at least one limited partner. The general partner makes the management decisions, has full liability. The limited partner does not make management decisions and therefore has limited liability. In an LLP, your members can participate in the management of the firm and they enjoy limited liability. So it's kind of like a hybrid of the general partnership and the limited partnership. Everyone can participate in management and you have limited liability. So that sounds like a great option, right? So why would you form a limited partnership instead of forming a limited liability partnership? It's for what I talked about, maintaining control. Forming a limited partnership allows you to take on new investors, right? To be able to raise capital without giving up the control of your business. Now, we're going to talk about the LLC next, but I'll tell you now, why would you form an LLP instead of an LLC? Simply because California law does not allow certain professionals to operate under an LLC. Law firms, accounting firms, engineering firms, architecture firms in California, those types of firms cannot operate as an LLC. Instead, they must operate as an LLP. The limited liability company. So I'm probably preaching to the choir, all of you business organizations or you business owners, you know this already. A limited liability company, it's a hybrid between a partnership and a corporation. In an LLC, you have pass-through taxation like a general partnership. So the LLC doesn't have to get taxed, but the owners get taxed. And in an LLC, you get limited liability like a corporation. There can be two different types of LLCs. When we talk about the management structure, you have a member managed company and a manager managed company.
Hello?
In a member managed company, all of the members have a right to participate in the management. But in a manager managed company, the members hire a manager to run the business. And finally, in a corporation, your decision makers are your board of directors. They set the policies and they delegate the day-to-day management to an executive team, creating a centralized management structure. The shareholders only participate through their power to vote at shareholder meetings. So if there's all of this, red tape associated with corporations, why even bother? And that's because of the limited liability that corporations offer, right? If the corporation goes under, they don't take your house, okay? And you also have flexibility in capital financing options. So entrepreneurs, someone earlier asked or said that they want to know how to raise money for their business. So entrepreneurs, what's one way that you can pay for labor when you don't have any money to give? You can promise ownership in your business, or you can promise a position within the company. If you contribute $10,000 now, I'll make you the CFO, right? When a corporation has profits, the management, the leadership of a corporation has to make a decision on what to do with that money. If the corporation, there we go. If the corporation wants the profit to its shareholders, they do that by issuing a dividend. We talked about that earlier, okay? Now, the corporation doesn't have to issue dividends, right? It's a choice that their leadership makes. The company might want to save that profit for a rainy day. And when you're in business, you will have a rainy day. Or the company may want to reinvest that money into a business opportunity or maybe into its facilities. So if any of you have shares in Google, right, you probably have not received a dividend, right? And what Google does is instead of issuing dividends to its shareholders, it reinvests the money into its facilities. It reinvests truly into its human capital, right? For those of us in California, we all know someone who has worked at Google, right? And we've all heard of the amazing facilities. We've heard of the transportation, the cafeterias, the childcare facilities, the rest areas, all of the health and wellness options that are available, okay? So if you are a shareholder for a corporation, if that corporation has profits but decides not to issue a dividend, you need to know what the corporation is doing with those profits, and you need to be okay with that.
Brianni, can I interrupt real quick? There was a question from Lisa Dean. She's stating several people I know have an LLC, but it's just themselves, no member. Is that acceptable? Can they be the manager and member at the same time?
So yes, it is possible to have a single member LLC. That's possible, Lisa. Thank you. All right. So those are the business organizations. Okay, we identified the different types and we discussed the key similarities and differences. The last key similarity and difference that I want to talk about are the fiduciary duties. As business owners, starting businesses or growing your business, you should be aware of the fiduciaries that either currently or will exist in your business. We'll talk about what a fiduciary duty is, but just know that in a general partnership, all of the owners owe each other a fiduciary duty. In a limited partnership, the limited partners owe each other a fiduciary duty if they participate in management. In an LLC, the owners are each other's fiduciaries when you're in a member managed LLC. And in a corporation, the board of directors, the officers of the corporation, and the controlling shareholders owe a fiduciary duty to the corporation. What is a fiduciary duty? A fiduciary duty is a duty to act for someone else's benefit while subordinating your own interest to that of the other person. So if anyone on the line is a parent or a spouse, okay, you know exactly what it's like to put someone else's interest completely before yours. That's what a fiduciary is. That's what the fiduciary duty demands, okay? So it's the highest standard of duty implied by the law. If you owe someone a duty, you are called the fiduciary, and to whomever you owe the duty is called the beneficiary. There are a couple of different types of fiduciary duties, but today we're going to talk about two of them that you find commonly in all business organizations. That's the duty of care and the duty of loyalty, okay? The duty of care says that a fiduciary must exercise reasonable care to protect its beneficiary from risk, okay? What's reasonable care? And that's when you act with the care, competence, and diligence that would be normally exercised by other fiduciaries in similar circumstances, okay? So what's a duty of care that we can all relate to? Our doctors, right? Doctors owe us a fiduciary duty of care. If your surgeon shows up to your procedure inebriated, they are absolutely breaking their duty of care to you, okay? And it doesn't matter if the doctor has a high tolerance, right? The duty of care imposes a reasonable care. It says the care, competence, and diligence that would be normally exercised by other fiduciaries in similar circumstances. So it has nothing to do with what you thought was the best option. It's what a reasonable person in a similar circumstance would think. Secondly, we have the duty of loyalty. The duty of loyalty says that a fiduciary cannot take self-serving advantage of the beneficiary, and that the fiduciary must work for the beneficiary's interest, even if it conflicts with the fiduciary's own interests. So say you are the CEO of a radio, or you're the manager of a Radio Shack, right? If Radio Shack still exists. And you on the side, you have your own electronic repair company, right? If you come across a business opportunity that would equally benefit the Radio Shack as well as your electronic repair company, if you have a fiduciary duty of loyalty to Radio Shack, you are prevented from exploring that business opportunity for yourself. In corporations, if a corporate officer encounters some kind of conflict of interest like that, say it's the CEO would be required to present that business opportunity to the board of directors and first get the board of directors consent, right? You first have to ask the board, do you want to pursue this business opportunity for the corporation? Okay, no, can I have it for myself? You have to get the consent of your beneficiary. Okay, so we've gone over the BPC, we've identified the different business organizations, we've talked about fiduciary duties. For those of you who are looking to start your business and you haven't formed it already, if you're ready to file in California, here are just some, right, of the forms. Here are some of the forms that you would be required to complete and file with the Secretary of State. There's a filing requirement in California for all of these business organization types, except for the sole proprietor. So if you are a sole proprietor, you don't have to file any paperwork to operate as a sole proprietor. Now you should get a federal employer identification number, and you get that through the IRS. But you don't have to file any documents to be considered a sole proprietor because you and your business have the same legal identity. However, if you decide to go by a name other than your name, you are more than likely going to be required by your local county to get a fictitious name permit, Okay, and we talked about a fictitious name permit earlier. It's the legally recognized alias of your business. Now, why would you need an alias? Well, maybe it's for marketing and branding purposes. Okay, you want a catchy name, or maybe it's to protect your privacy. Again, as a sole proprietor, your identity and the identity of the business are the same. Business records are typically public documents, okay? As a sole proprietor, say you want to file a trademark, okay? The trademark's gonna ask for the owner's name. You don't wanna have to put your home address on the federal government's website available to anyone to see, right? So maybe you file a fictitious name permit where you give an alias, you give a separate address, a different phone number. These days you can have a virtual address, a virtual number, okay? So keep that in mind for the sole proprietor. Okay, so if there are any questions, could you let us know in the comments? Questions, or maybe you can share with us something that was new information to you today. So if you have a question or you would like to tell us, this is what I learned today, I'm glad I learned it, that would be greatly appreciated.
Hi, Brianna. This is Chow. Can you hear me?
Hi, yes, I can hear you.
Hi. So my question is, let's see. So I filed with the Secretary of State the Statement of Information. And on that form, it asks you if there is a manager that has been appointed, or if there's member, or if it's member operated. And then it asks you if it's member operated, how do you, and it says Chief Executive Officer if elected or appointed. So is that how you are naming yourself separate from the, let's see, separate from the business? I'm just trying to understand, like when you sign a document, you sign it on behalf of the LLC versus on behalf of yourself?
Okay, so I'm not 100% clear on what you're asking me, Chow, but I'll tell you this, right? And I don't understand your circumstance, and I can't even advise you specifically on your circumstance. But when it comes to authority, that's something that I decided that we weren't going to touch on today.
Okay.
Authority is this concept where an agent has the authority to make binding decisions for its principal, okay? Now, authority can be something that's granted, right? Or it can be something that a reasonable person would assume, okay? So what I'll say to you, Chow, is that if you are signing documents on behalf of the company, then chances are, right, the company, right, will be liable for that. So if you sign saying, I am this person, I have authority to bind the company in this way, the company will likely be held to that.
Okay.
Now, separately, I will say you all that filing documents to form your business, that can be, it's an entire workshop on its own. So Chow, if you would like for us to have another webinar where we go over the documents, right? Please let us know, and maybe the Women's Center can make that happen.
Okay, yes, that was very, very helpful. Thank you.
Yeah. Lisa asked, as we start up our business, are there other things we need to do that you are aware of? Lisa, when you start up a business, there are a million things that you can do, right? So it's important that you have a team of professionals that can advise you on the necessary steps to take, right? Not one person can give you all the advice that you need. You're going to have a lawyer, and separately an accountant, right? So something that we didn't talk about today, but I think is extremely important for all entrepreneurs to consider, is your contracts, right? We talked about the different business organizations, how to file them. We talked a little bit about insurance. And we talked a little bit about trademarks, right? But what about contracts? Okay, depending upon what your business is, you might need employment agreements, you might need non-disclosure agreements, maybe you're purchasing large quantities of products, you need a purchasing agreement, right? So I think contracts are another really important area for entrepreneurs to think of. Okay.
I have a question.
Yes.
I actually am in the process of trying to build contracts for my organization. Any advice on how to get that done?
Contracts, there's a lot of information out there about contracts. There are a lot of really cool resources that are available to people when it comes to contracts. So there is a website, I think it's either Practical Law or Law Insider. I think it's Law Insider. There is this website that houses this database of different contractual terms, right? So say you're drafting contract and you're trying to, say it's a non-disclosure agreement, and you want to figure out how to define confidential information. This website will show you all of the different ways, right? Or just different examples of how people have phrased that provision before. Depending upon what state you're in, I'll tell you that in New York, there is an organization called the New York State Bar Association. It's a professional organization for New York lawyers. It's pronounced NYSBA. NYSBA offers publicly for free certain templates. Okay. I want to say that the American Bar Association does as well. So there are a lot of different, you can find templates on the internet, you can find different versions of clauses. Oh, also, Preston Law has a YouTube page where they do a contract teardown. If you Google Preston Law contract teardown, it should come up. And they have a lawyer talk to another lawyer about some use case contract. So maybe Oracle, right? If you're in California, we're all familiar with the Oracle arena. Oracle is an actual company. They have taken certain provisions of the Oracle licensing agreement and they've explained them, right? Kanye West, there is something controversial with him in a contract. I want to say they also did an episode on his contract. So tons of resources out there for contracts. Yeah, tons of resources out there to just see what they're like. But of course, I have to tell you that, consider consulting legal counsel to make sure that what you want, right, actually gets put on that piece of paper.
That's super helpful. I've learned so much on this, Brianni. So impressed. And you look incredible. Thank you so much.
Thank you. Thank you also to Mr. Morris in the comments, all that you learned. Really, really appreciate it. Lisa, I'm glad I answered your question. Excellent. Okay, well, so if you all have any additional questions, maybe you're scared to answer them, or maybe it's more appropriate for a different venue. If you want to contact me, I invite you to reach me on LinkedIn, or you can schedule some time to talk with me, and you can schedule that through Calendly. So again, I really appreciate everyone's participation, your attendance. I hope everyone learned something. It's been a pleasure.